And there are no shortcuts to success in our profession. It requires a tremendous sacrifice, especially personal sacrifice, personal relationships, in some instances, family relationships. It is a very demanding profession. It is not for the weak of heart. So unless you can give it 150%, you probably ought to be doing something else, because you're going to end up putting those clients before yourself. And that means you're going to put them before some of your family obligations at times. The profession requires it. The client's cases require it. Nothing less than your very, very, very best.
Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are Robin Fraser Clark and Lester Tate, who are both past presidents of the State Bar of Georgia and currently serve on the board of directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am Robin Fraser Clark, and with me is my co-host, Lester Tate.
Good morning,
how you doing,
Robin?
Lester? Good morning.
How are you?
I'm good. How are you?
I'm doing great. I think the last time I saw you, we were in beautiful Maui, Hawaii, and
oh my gosh,
one of our benefactors with us today.
That's right. Gosh, yeah. I'm still on the Maui high.
I'm still on the Maui time zone. I don't want to get up till about 6 hours after I typically get up. You know,
that time zone change was a doozy. I'm not gonna lie. That was rough, but it was worth it. It was so worth it. Absolutely. And still proud of the Tar Heels, but still a little tiny upset, a little bit upset that we fell about 3 points short. But it was a great season for the Tar Heels.
This would be the time that I would need to point out that my Carolina, the real Carolina, South Carolina, where I went to law school, actually came through and won the women's national title running away. And I'm so proud of Dawn Staley and those young women for doing that. It's interesting to me, you know, I graduated from Georgia Tech, and then I graduated from South Carolina Law School, and absolutely the most accomplished teams at both of those schools are the women's basketball teams.
Yeah, congratulations to them. They had a great year, and so proud of them. Well, we mentioned our guest indirectly when we mentioned Maui, because our guest, Ray Persons, was the driving force to get us out there, which was just an incredible trip. And we're going to talk a little bit about that. But let me introduce our listeners to our guest, Attorney Ray Persons, incredible lawyer, amazing friend, and we're so thankful to have him with us today. Ray is a trial lawyer here in Atlanta with the firm King Spalding, and he's currently president of the International Society of Barristers. He is a senior litigation partner at King Spalding, an international law firm that represents a broad array of clients, including half of the Fortune Global 100, with 900 lawyers in 23 offices in the United States, Europe, the Middle East, and Asia. Ray has a national practice focused on product liability, mass tort, class action, and complex litigation. Ray has represented more than 50 of the Fortune 500 as counsel or national coordinating counsel for clients in the pharmaceutical, automotive, chemical, and energy industries. He has served as lead counsel in 92 jury trials. That number may have changed by now, but we'll talk about that. 90% of which went to verdict. He has served as lead counsel in over 25 Engle progeny tobacco jury trials. He serves as national counsel in NRE-UST litigation for one of the world's largest petroleum companies in claims brought by dozens of states alleging fraudulent overpayment of claims for reimbursement of costs associated with cleanup of underground storage tanks. He served as national coordinating counsel and lead trial counsel for Union Carbide Corporation in the successful defense against claims of an alleged industry-wide conspiracy to subject workers to cancer-causing chemicals. He He represented one of the world's largest pharmaceutical companies in a 442 plaintiff case involving claims of exposure to arsenic and chromium stemming from the 60-year operation of a manufacturing facility in New Jersey. Ray successfully defended against claims brought by 1,200 homeowners and residents who lived in the vicinity of a fertilizer plant. The chemicals of concern were arsenic, lead, mercury, and sulfur dioxide. Ray is regarded as one of the best trial lawyers in the country, as evidenced by his election as a fellow of the American College of Trial Lawyers, the International Society of Barristers, and Litigation Counsel of America. And as I told you before, he's currently president of International Society of Barristers. He is a member of the Defense Research Institute, Federation of Defense and Corporate Counsel, International Association of Defense Counsel, and American Health Lawyers Association. Ray received his undergraduate degree in 1975 from Armstrong State College and his law degree in 1978 from the Ohio State University. I guess I should say the Ohio State University. He was awarded the Armstrong State University Distinguished Alumnus Award in 2000, the Moritz College of Law 2005 Distinguished Alumnus Award, the Ohio State University 2006 Distinguished Service Award, and the Ohio State University 2012 John B. Gerlach Senior Development Volunteer Award. Wow. Incredible, incredible. Ray, welcome to the show.
Thank you, Robin, and thank you, Lester, as well.
Well, I'm gonna jump in real quick and say I don't think you included one of the most important parts of Ray's biography, because Ray started his career, I think, right after law school. Ray working for Lindsey Thomas, a Georgia congressman, when I worked for Congressman George Buddy Darden, and Ray and I have known each other, I know, since at least 1983, which was before I was a lawyer. It's just so nice to have a friend of such long standing and such great accomplishment, and to have him here talking today.
Well, the feeling is certainly mutual. Absolutely. And I had been practicing law for a few years when I went to Washington with Thomas. In fact, I was practicing in my hometown, which is Hinesville, Georgia, in Liberty County on the coast, and was counsel for the regional counsel for the NAACP. And in that capacity, I met Lindsey at a small church in McIntosh County. And he apparently was impressed enough with me that when he got elected to Congress, he invited me to be on his staff. And that was a very enriching experience and has helped tremendously in my development as a lawyer, because in a congressional office, you deal with all kinds of problems and all people from all walks of life, everything from handling a Social Security claim that someone has to writing legislation and getting funding for the Talmadge Bridge. And so all of that has contributed to the success I've enjoyed in the practice of law.
I think also, Ray, you talked about where you first met Lindsey. You get to go to a lot of barbecues and parades and all this other stuff, and you really get to meet the folks that are frequently sitting on juries. And that's just one thing I really admire about you. You're with a big firm. Robin has told us about the global span of King and Spalding, but they're lucky to have you, because despite their corporate silk stocking credentials, they've got a guy who doesn't eat chicken with a knife and fork.
That's right. You got that right. And I'm not alone in that. The firm has had a history over the years of reaching out and recruiting lawyers outside the firm, some from very small firms, but who have a trial resume. And an example of that would be Griffin Bell. And when he recruited me to King and Spalding, he pointed out to me the fact that he was with a small firm in Rome, Georgia. King and Spalding at that time had about 12 lawyers, and he thought they were too big, that they really couldn't afford to pay all those people. So he insisted on seeing the books, because he didn't think that they were really making the kind of money that they claimed they were. That's a true story. And he said to me, and I'll never forget it as long as I live, he said, "Ray, if you join us, I'm going to tell you the same thing that Mr. Hugh Spalding told me. Hugh Spalding being the son of Jack Spalding, who was one of the founders. He said, we'll give you plenty of backup. And that was true. But he wasn't the only one. We had others like Frank Jones, who came from Macon, from Jones, Cork, and Miller. We had Mr. Gower from Brunswick. We had Charlie Curbo, came from Bainbridge, and a two-person law firm with his brother Bruce, but he was one fantastic trial lawyer. So we've had a history of doing that, reaching out and getting top-notch trial lawyers who can relate to people and relate to folks from all walks of life and who really just enjoy lawyers and trial lawyering.
Yeah. You know, Ray, your experience starting out as the congressional aide, did that ever make you want to consider running for office?
You know, that's part of what led me back home to Hinesville. I had worked in Atlanta. In fact, I started my career at a large firm, Troutman, Sanders, Lockman, and Ashmore, now Troutman Pepper. And I wanted to get in the courtroom, but I also wanted to do something in the way of community service and give something back to people in coastal Georgia, where I'd been raised. And so I had the idea of running for the state legislature after building up some, cred in my community. But the folks in town, I was going to say the city fathers, but the city mothers as well, they thought this would be a great opportunity for me to do something on a broader scale to help coastal Georgia. For those who do not know, Hinesville is the home of Fort Stewart. And most of the land in that county is occupied as federal land. And so it's not taxable. So we depend heavily on the presence of the military installation as well as funding from the federal government to replace the loss of funding due to the land not being taxable. And so that was seen as something I could do to help out. And it was deeply rewarding.
I mean, it certainly sounds like it, and definitely set you on a path, obviously, that is just your trajectory has been straight up.
It really has, Robin. That
It's
set me on my way.
Mm-hmm. It's wonderful, wonderful story. I said in the intro that you had tried 92 jury trials. Is that accurate, or is it more now?
I think that's probably true at last count. We haven't done a count in a couple of years. I might have one or two more, but it's not even worth updating the bio to do that. And so, but yeah, that's a lot of trials. And I've been very fortunate that have been called upon to take cases to the jury.
First, I'm wondering if in the vast firm that is King and Spalding, do you think you're the person who's tried the most trials of anybody there?
That's true. Yes.
No question about that, right?
No question about that. That's right. That's beyond debate.
And Lester has tried over 100. I've tried 75, which I think is a lot. Lester's over 100. You're at 92 or so. Yeah. But what we're seeing, Ray, is that younger lawyers now don't have an opportunity to try cases much.
You're right.
Are you seeing less and less opportunities for that?
Absolutely less. And that's one of the reasons why I'm a big proponent of our tobacco practice. Those cases get tried. I don't know how much longer we're going to be able to do that, but I got involved in tobacco work back in 2011, and I've tried at least 25, probably more like 30 of those cases now. And I've trained other people to do it. Bethany Snyder, who's a prominent plaintiff's lawyer now, I trained her on tobacco. Frank Bayek, who's still doing defense work, he's at another defense firm. He's at Jones Day now, but I trained him. And then there are lawyers who are still at King and Spalding, who have grown up on tobacco work, because that's the only industry that's still trying a lot of cases. And there's just such a dearth of trials anymore. So they're not getting the experience that you and Lester and I were able to get over the years. And I wouldn't have had nearly as many trials had I been at King and Spalding years ago. I started trying a lot of cases when after I came back to Atlanta from Washington, and was representing MARTA, representing Waste Management, representing Allstate, State Farm, trying just car crash cases. But I tell my young lawyers, no matter how small the case is, you have to do jury selection. You got to do an opening statement. You got to do cross-examination, direct, and you're going to do a closing argument. So you learn even with the smallest. So seek every opportunity to get into court that you can. And I've taken on a lot of these prisoner rights cases on a pro bono basis to get my younger lawyers courtroom experience. And so we've got a number of those going right now, these 1983 cases, and they're taking them and they're running with them. But that's giving them a chance to get into trial if they aren't doing tobacco. If they're doing tobacco, then they can, not that they can't do both. Some do both, but it's especially important for those who aren't involved in the tobacco wars.
So I think, Ray, you and I tried a road wreck case against one another. Actually, you had a younger person you were training, then.
I did.
Hugh Lawson over in Athens.
It was a federal case now.
It was. Absolutely.
And we lost. You beat us down fair and square, but it was a fair fight.
It was a fair fight. It was a fair fight. Because Ray just watched the other side be tried. I tried my own side, but Ray didn't wade into it very much. But I was thinking as we're talking about, like Robin talks about, I had to count up for like a BOTA, and I think I had about 75 felony, criminal, and civil cases. And what puts me on up ahead of that in terms of jury trials is I've tried a bunch of misdemeanors, over the years too, not just murders and federal criminal cases, but some, a few DUIs and a shoplifting, now and then. And so I think for our listeners, one of the things important is, and I'm trying to put myself in the mind of the listener, like you put yourself in the mind of the juror. And I think a lot of lay people think if you're a trial lawyer, you're out trying a case every week, every Monday morning, you're going to the courthouse. And, that doesn't happen, particularly as you get further and further in your career. And you see that in, even in foreign countries that like Great Britain, if you become a Queen's counsel, you're not in court, every day, which is one of their higher levels of the bar. And but the cases that you're trying, a lot of those are week, 2 week, 3 week long. And I know some of them too, like the tobacco cases, that's, I'm guessing, probably like an asbestos case where it's sort of the same trial over and over to some extent. But talk about the wide range of cases, that you've tried and what the difference is in the way you approach them and, how you try them.
Well, everything from a car crash case, and the approach is very similar, except when I was trying those cases, over 40 years ago now, I'd go to trial by myself, or at most I'd have a paralegal if they'd pay for it. And everything that I needed, I could fit in one banker's box. And back in those days, we had the 30 by 40 boards, and you were doing something if you had one professionally prepared by Trial Graphics or somebody like that. Now you fast forward and you go into trial and you've got a whole team of people, at least a dozen when you count the tech people who are doing the in-court presentation, the consultants, the associates, the paralegals, the secretaries, the senior associates, and the junior partners. But the approach is still the same. You got to prepare, and that gets harder and harder the older you get because it's a physically demanding endeavor, as anybody who's tried cases know. You can't be lazy and try cases. It's just not possible unless you're just going to go in unprepared. And so you're diligent in your preparation. One of the things I learned from the late Bobby Lee Cook when I'd asked him about the secret to his success, and this was over 35 years ago, he said, well, in any case I try, if there's a depositions, I read every deposition and don't overlook any witness as being somehow unimportant. So I read everything that I can get my hands on, And my objective is to go in and know more about the case than anybody in the courtroom. Well, whether it's the youngest person on the file to the oldest. And only then am I comfortable enough that I feel that, okay, I can go. I'm ready to go. But you can never be too prepared to try a lawsuit. There simply is no such thing. So it's all in preparation and hard work. I'm not, somehow brighter than everybody else, but I just outwork a lot of people and have done that over the years. And I found that the harder I work, the luckier I got. And so it all comes back to the lessons I learned in a small town growing up. The importance of hard work and diligence and studying, and it's paid off.
In preparation and in money, there's only two states: none and not enough.
That's right. I like that. I'm gonna remember that. I'm gonna use that.
We call that good old fashioned elbow grease, Ray.
That's right. That's what they call it. That's
good
right.
old fashioned. I was talking to Steve Lowry on his podcast one time and talking about getting ready for a cross-examination of an expert witness, an anesthesiologist who had written hundreds of journal articles, and I had read every one of them. And Steve said, how do you do that? I'm like, it's called good old fashioned elbow grease. Right. You just do the work.
That's right.
You just do the work.
You have to do it. And it's when nobody's looking, that's when so much of the work gets done late at night and drinking cold coffee and eating cold pizza or whatever you have is handy. You're putting in that time. On Sunday afternoons after church, when other people are going about doing things with their families, well, you're in the law library. And that's been true at King and Spalding, and it was true when I was in a small practice. There's just no substitute for putting forth that kind of effort.
Let's talk a little bit about some of the cases that you're handling now, or kind of your book of business now. We've talked about the Engle tobacco cases, and just if you could, for our listeners, in case there's some folks out there, some lay folks that may not be familiar with Engle tobacco cases, can you give us a little bit brief about what that is about?
Absolutely. Engle was a class action that was brought back in the 90s. And it consisted of a class comprised of all Florida smokers who suffered from a smoking-related illness or died from a smoking-related illness. And the case alleged product defect, that the cigarettes were defective, and that led to the injury and death. The case was tried over the course of several months, resulting in a $145 billion verdict. On appeal, that got reversed, but the Florida Supreme Court kept the findings. And so the findings were, they're just a multitude of things: that the tobacco defendants were negligent, that the product was defective and unreasonably dangerous, that they conspired to conceal the adverse health effects of consuming the product, and those who could establish class membership on an individual basis by demonstrating that they were addicted and that the addiction caused the injury or the death, those findings became res judicata. They were established. We can't challenge the findings. Once they establish the requirements for class membership, addiction and addiction causation, then they're class member. And so what we do on the defense side of the case, we can't dispute those things. What we can dispute is whether the person was in fact addicted to the point that they couldn't quit. The converse of an addiction that's so overwhelming that you continue that practice or that habit until you develop an illness is that you're able to quit. So that should break the chain of causation. The other thing is they've got comorbidities, other conditions that contributed to the illness or the death. We use that information, that evidence, in defense of the cases. And in so many instances, it comes down to someone's they enjoy smoking. They knew it was harmful. They were warned by the doctors to quit and just took no steps to quit smoking. And therefore, it wasn't the addiction, it was their own choice. And so choice becomes a defense. And so that's how the cases are defended. My client is R.J. Reynolds, which is not just the original R.J. Reynolds, but it's also American Tobacco Company, which they bought, which is the maker of Lucky Strike. Brown and Williamson, the maker of Cool cigarettes, and they purchased Lorillard. So all of that legacy litigation is what comprises the R.J. Reynolds docket now. So that's the long and the short of it. The verdicts in those cases have ranged from, defense verdicts to over $100 million in a single plaintiff case. So it's a very, very dangerous kind of litigation. The cases that I'm called upon to represent Reynolds in are in the most dangerous venues in Florida, that being Alachua County, which is the home of Gainesville, the University of Florida, Broward County, Fort Lauderdale, and Miami-Dade. And so that's where I get sent in. And so I've lost some big numbers. I've won some, but I've lost some big verdicts because the punitive damages are just, as you can imagine, with a product which is so controversial as tobacco, and given the conspiracy claims and so forth and the misinformation campaigns, it makes for a dangerous mix.
That's one of the things, like all three of us sitting here, I think, have done civil defense work and then plaintiff's work. I think Robin left the defense world completely to go to plaintiff's work. Mm-hmm. I, for a long period of my career, represented the power company and was a plaintiff, kind of like Hugh McNatt, but did the other. But for folks like you who get to the pinnacle of defense work, and I had a mentor of mine who was a top-notch defense lawyer, he once said, "You're never going to be regarded as a great defense lawyer till you really get your ass kicked, a time or two. That's and true. Get big verdicts against you."
That's true.
And I think one of the things, you're sort of a professional stone catcher here, to go out and try to fend these things off. And I mean, like what you've just described, but the way the court's ruling were really put it on the tobacco companies, like tied your hands a lot as to the defense. But even in cases where that's not there, don't you find that in a lot of these cases, the corporate America knows they're going to suffer a verdict, and a win for you is just to sort of keep it down. I mean, I remember one time I got a $50,000 verdict against me early in my career, and I was really happy about it, that it was only $50,000. Right. But that's not a drop in the bucket compared to what you're doing.
It was a whole lot of money back when I was defending Allstate. I mean, they would send you to court to defend against a $15,000 claim. I don't know if they do that now. But, but yeah, you're absolutely right. It's a matter of just keeping the number down. If we can't agree on it, I try to settle every case. Number one, if the case ought to be settled, I mean, and so many of them, they should be. But if we can't settle it, then we take it down to the courthouse and let the jury decide. And that's how it should be in this country. I do the best I can for my client, whether I'm on the plaintiff side or on the defense side. Most of the work now is defense, but then I do represent plaintiffs, especially in some of the commercial cases. And so, you do your very best if you're on the defense side to hold that number down. I remember when our current chairman of our firm, Robert Hayes, and I were in trial over in Alabama against Jerry Beasley, representing General Motors in a automotive crashworthiness case. And we got hit for $105 million. And the National Law Journal used to have those top verdicts. Well, that thing stayed in the top 10 for the rest of that year. I think we tried the case in March. And so every time the National Law Journal come out, we'd see if that thing was still in the top 10. Well, come December, it was still in the top 10. Somebody, I can't remember who it was, a friend of mine, called up and he said, Ray, I see where you got hit for $105 million. You're really trying big cases now. And so I remember telling Robert about it, and I said, that's a compliment. We could make this thing work for
Yeah.
him.
It is a compliment.
Right. You're absolutely right. I mean, for somebody to trust you with that kind of money, I said, okay, or exposure, then yeah, you're trying big cases now. Unfortunately, it's on the other side. And like my late friend, Tommy Malone, who was one of my closest friends in the world, he would often say to me, he says, the problem you have is the more senior you get and the more experience you get, the harder your cases get. And with me, the easier they get because I get to pick and choose.
Mm-hmm.
And I don't necessarily get to pick and choose. Man, if I did, I would pick some that were a little more winnable.
Good point. I take it the three counties you appear most in down in Florida in the Engle's cases are the three largest plaintiff-friendly counties in Florida. Is that fair to say?
That's fair, Robin. Absolutely, they are.
Yeah.
Yeah.
I got that. Some other kinds of cases that you're working on and actively trying cases in, I guess, are the other you mentioned some medical products cases,
right,
like the mesh cases. Can you talk a little bit about that work that you're doing?
Certainly can, yes. The polypropylene is the material that is used in the construction, if you will, manufacture of the mesh that's used to address female urogynecological issues, the pelvic issues, whether it's stress incontinence or prolapse, where the organs basically descend and extrude outside of the body, whether it's the bladder, sometimes it's the colon. I mean, and so those are very problematic, very difficult medical issues that a sizable segment of the population faces. And so one of the problems with these devices is at times there's what's called an erosion, where it ventures into an adjacent organ, or there's an exposure where the wound simply doesn't heal and the mesh is exposed, and that creates problems for the patient and the patient's sexual partner. And so those are the kinds of cases that they've been around a while now, but I'm involved in defending those down here in Florida.
And then also, I know you did mention a products liability for a manufacturer of a car case against the Beasley firm, but can you talk a little bit about that? I know you've handled many products liability defense for car manufacturers in what we call crashworthiness cases.
That's right.
Can you tell our listeners a little bit about that kind of work? What is a crashworthiness case, and who do you represent in those kind of cases?
The manufacturer is who I represent in crashworthiness litigation. And basically what crashworthiness is that it's the ability of a vehicle to withstand a collision or a crash with minimal bodily injury to its occupants. So the ability of the vehicle to protect the occupant of the vehicle. Now, no vehicle can be constructed that would protect the occupant entirely. I mean, even tanks, if you collide two tanks, the shock would result in injury to the occupant. But the National Highway Transportation Safety Administration requires that manufacturers meet certain standards of crashworthiness and that the occupants are protected. You've seen these crash tests and read about them in consumer reports. And that's what that all is intended to do, is for the manufacturer to demonstrate that the vehicle is capable at certain speeds to protect the occupant. The case that we had against Jerry involved a head-on collision between two cars. That was a Pontiac Trans Am was the was one of the vehicles, but the vehicle that was the subject of the lawsuit was an Oldsmobile 88, driven by a 16-year-old boy, and his front seat passenger was his 9-year-old brother, who in the crash suffered a penetrating head wound, and it resulted in his having to undergo a lobotomy. He went from being in the 98th percentile in terms of intelligence to the 5th percentile. So it's a horrific injury. And it was the plaintiff, the father of this child, was the clerk of the court who sent out all the jury summons and signed them, and very prominent in that county. And so everybody knew this family and knew what this family had suffered as a result of this child's horrific injury. And so it's just very, very difficult case for a jury not to be swayed by sympathy. We tried to settle the case. We couldn't. We tried the case. It went up to the Alabama Supreme Court, and they reversed it, and on 4-3 decision. 3 wanted to render. And so we went back and teed it up to try it again, and it settled for what we'd offered the beginning.
Wow.
And so that was a very tough case, though, because in order to do this work, you got to have empathy. I mean, you just can't be in my opinion, a very effective trial lawyer without genuinely caring about people. It shows if you don't. And it was hard to address this case because you're so mindful of the needs of that child for a lifetime of care, the impact on the family. If you've got any compassion at all, you're going to be affected by it. You get out and you get up and you do your job, but you're never unmindful of the human element of the cases that you handle. You can't be indifferent to it. And so I was glad we were able to settle the case. It will fund his care for a lifetime and provide additional resources to compensate. There's never adequate compensation for something like that because of just the loss, the toll that's taken. But to the extent we can do it with money, that's what we do in our system.
When you I had a professor in law school that once said, if a case goes to trial, it's probably because one of the lawyers has misevaluated it.
That's probably true.
I wanted to know what you thought about that.
I agree with that. I've misevaluated them, and the other side has misevaluated some. We learned that when the jury comes back, but yeah, that I think that's spot on, Lester. I do, and Tommy Carlock is one of my heroes and mentors, and one of the things I love about Carlock is he's so disciplined in his case evaluation, extremely disciplined about it, and has a great sense of proportion. And so, no, I totally agree.
Tommy and I had one where we both misevaluated it. It was a med mal case, and we went to trial, and the jury hung.
Well,
so we were both wrong, about
what was
the outcome. But I frequently tell clients my crystal ball's in the shop this week. I can't see what 12 people unknown to me now are going to do with this in the future.
I'm with you, buddy. I mean, as many times as I've done this in as many places over the years, I can't predict what the outcome is going to be. I do the best I can to prognosticate, but I certainly can't, not with any mathematical certainty, tell somebody the outcome. I can give probabilities, and that's about it.
When I'm telling a client about possible results, if we try the case, I never include could be mistried and we have to try it again. I never think to include that, although I've had one mistrial, and it's a nightmare for I'll just tell you, it's a nightmare for the plaintiffs to have to try too. My friend Adam Malone says trying a case twice, it's like going out and working out and getting all good and sweaty. Take your clothes off, take a shower, and then after you get out of the shower, you have to put your sweaty clothes back on.
That's a good analogy.
I have hung jury on 4 4 cases, and 3 of them, of all the places I've tried, 3 of them have been in Floyd County, Georgia. And those 3 were a medical malpractice case, a murder trial, and a misdemeanor stalking case. and I don't know what it was in the water in the Coosa River up there that those made those jurors, hang up on those kinds of cases, but all totally different, sorts of things.
Well, it's like Hugh McNatt was telling. I tried a case up in Gainesville in front of Judge Story, and it was a automotive product liability case, and the jury was hung. We agreed to take a less than unanimous verdict, and we lost. I'd misjudged the way the vote was split. Blasingame Birch was on the other side, so it was delightful to try a case against them. I mean, we got along well. Judge Story is delightful, but I think some of that is North Georgia, Lester. People have such strong opinions about things. I remember Hugh McNatt telling me a story of a case he tried up for the power company up in North Georgia, and the judge inquired about, how things were going with deliberations, and y'all still haven't been able to agree on a verdict, and they said no. Said, well, is there anything that I can do the court can do to be of help? They said, you can send back some wrestling mats. So, I mean, he ended up declaring a mistrial, but there would have been a mistrial in that case in front of Judge Story if we hadn't agreed to less than unanimity, because those folks they were going to hang tough with whatever position they had taken. And that was just going to be it. There wasn't going to be any change. You're not going to change my mind about it. I've made up my mind about what the outcome ought to be based on the evidence, and that's it. Now, contrast that with where I'm from, coastal Georgia, especially if you're in Chatham County and Savannah. If it gets to be 5 o'clock, and especially if it's on Friday, there will be a verdict because bars are going to be open and people, that's just a whole different mindset in terms of how things are going to be done.
I've heard Bobby Lee talk about that before, about North Georgia, and we are Scotch Irish dirt farmers. Weren't any plantations of mansions, like right. Down in Savannah area and stuff like that. So I think it is an area where individualism, is probably.
I think that's true.
Probably quite prized. I tried a case one time for 2 sisters where we're in a car wreck and we tried it together. And one of them sort of complained a lot because she had a lot of medical bills. The other one didn't have as many medical bills. When she got on the witness stand, she said one of the things that it had messed up, she's about 75 years old. She said, it's messed up my deer hunting. And the defense lawyer said, you can't deer hunt anymore? She said, no, I still hunt deer, but this is the first year I've not been able to drag what I killed out of the woods. And they gave her more money than they did the sister who by medical bill amount was hurt worse, because she was trying and she was struggling. And they could,
that's right.
They could see that,
They wanted to compensate. They wanted to reward that. Yeah. That's right. Not somebody just sitting back, just complaining about the ailments.
Right.
Mm-hmm.
Ray, do you have any idea how many states you've tried cases in? Sounds like you have to do a lot of traveling.
I do. I have over the years. I don't have a count. But right now, most of my work is in Florida. That's going to change in the fall. I've got a trial in Madison County, Illinois, and then another one out in California. But yeah, most of it for the last few years has been concentrated in Georgia and Florida, some South Carolina. But that's been easier than this national counsel work that I was doing a lot of before, where you had to go all over the country from coast to coast. The vinyl chloride stuff for Union Carbide took me all over the nation, from California to New Jersey.
Are those Union Carbide cases, are they all wrapped up?
Yes. Yeah, they've been. Yeah, the last one was a West Virginia case, and it got wrapped up before the pandemic. I want to say like 2020, early 2020.
You mentioned to us that you have a trial coming up, I think in a couple of weeks.
Yeah, next
kind of-
week, as a matter of fact.
Next
Yeah,
week.
we're going to strike the jury a week from today.
What kind of case is that?
That is a week from yesterday. It's a medical device case. It involves a retropubic sling and vaginal mesh
And where are you trying that?
in Orlando, which is Orange County, Florida, and can be a pretty dangerous venue for a defense, especially in a case involving a medical device, which is, that's a foreign object. There's a foreign body response, which sounds pernicious, but I mean, that's just natural anytime you have something foreign put in the human body. And then, like I said, these conditions are just so life-altering and just devastating for the person who's suffering these ailments. And to the extent these devices can rectify it, and then if they suffer complications, it's just, there's a lot of sympathy for the suffering that these patients endure. And the cause of it, there are several factors: age, weight. They've had childbirth. If they've had multiple childbirths, that weakens the supporting ligaments and musculature in the pelvic region. So somebody sitting on the jury can easily say, well, that could happen to me, or someone I love, someone I care about, and it's through no fault of their own. And so it's tough. Those are tough cases.
You defend, you're a defense attorney, and we've been talking about your cases where you're defending all these companies and corporations. You did mention sometimes you're the plaintiff in a corporate litigation case, because my understanding about corporate litigation is it's whoever files suit first depends on whether you're going to be the plaintiff or defendant. But I'm wondering whether you ever were represented the plaintiff in a personal injury case. Have you ever done that kind of work?
Oh, heavens, yeah. I did a ton of that kind of work back in the 80s and even into the 90s. It was not uncommon when Marvin Arrington and I were practicing together. Marvin did a lot of criminal defense work. And we had a general practice. We didn't have a lot of insurance companies or institutional clients. Our aim was to try to build some of that, but as Black lawyers, we just didn't have that. And so whatever came in the door, basically, I've done everything from domestic relations. I've handled dog bite cases on the plaintiff's side, slip and falls on the plaintiff's side. I've handled aviation cases on the plaintiff's side. Now, that was after I was at Swift Curry, McGee and Hires. Glover McGee was a plaintiff's aviation lawyer, but he did defense work in other realms of civil litigation. And after the ValueJet crash, several of the families attempted to contact Glover. Ironically, Glover was in St. Louis buying another airplane. And so I had been engaged by Neil Pope, who had represented some of the plaintiffs. And so I had some familiarity with the litigation. And so I was in the office. This was like the day before Christmas Eve. And so I got the call and I was able to talk, intelligently about the ValueJet litigation, and we got hired. And so I handled those cases and a ton of those cases on the plaintiff side, and got them resolved. So yeah, that was some significant plaintiff wrongful death.
I've also heard that a defense lawyer with a plaintiff's case is like teenage boys with a bottle of whiskey. They're just sapping up every bit of it, and the judgment goes out the window when it's there.
Well, yes and no, because I had done enough when I was a young lawyer. That's how I cut my teeth on personal injury. That I knew not to get overexcited about it. I imagine if you got a defense lawyer who didn't have that background and had not as a young lawyer sat in somebody's living room, talking to them while they're trying to nurse a baby and keep track of a toddler, and explain why you are the person that they ought to hire to represent them, then they might look at things a little differently or a lot differently. But when you've been in that situation and it's on you in terms of whether this family gets some compensation or not, and you don't have a lot of backup, you've got a small office, you've got help to pay, and you've got to do what's in the best interest of this client, which might mean you got to go out and you got to borrow some money and sign a note in order to cover your overhead until the case resolves. So I've got a different perspective on representing plaintiffs than maybe some defense lawyers have. So it wasn't as intoxicating for me because I knew this is a case we could have lost these cases.
Yeah.
It wasn't a slam dunk. And so because we had to go out and we had to hire the right experts, we had to develop the evidence. And I learned a lot just working with Neil, because Neil doesn't take very many cases. And, he divides the work up amongst his partners where you're going to handle discovery, you're handling experts, you're handling damages. Ray and I are going to handle the courtroom work. And so that's, that's how we approached it. But he'd be the first one to tell you there's not a case that can't be won. There's not one that can't be lost either. So that wasn't lost on us. And, even if you prevail at trial, who's to say that you're going to win on appeal? I mean, so you have to take all of that into account.
But, Ray, I think that's why you have empathy as a defense attorney, because you have sat in a family's living room or kitchen while they made dinner. You have done that, and all plaintiffs attorneys have done that. I can remember one of my clients in her tiny living room, and the whole living room's taken up by a hospital bed they have to rent that she sleeps in now. She can't even get into her bedroom. But I feel like, not every defense attorney has done what you've done. They don't have that kind of varied career and experience. So I do believe that experience of representing the little guy gives you more empathy and more insight as a defense lawyer into what's going on the other side. I think it's very helpful.
It is, Robin, and it's helpful to my clients because I can give them the benefit of that kind of perspective when we're talking about evaluating a case for settlement that I wouldn't be able to do otherwise.
Absolutely.
And I'm not one of these people that's on a mission from God, if you will. And I'm not being sacrilegious in saying that, but it's as though some people just, they can't see the other side of the coin. They can't put themselves in the opposing counsel's shoes, if you will.
Yeah.
Mm-hmm.
And I never let it become about me and the other lawyer. It's about the case and striving to just get to a just result. And if one of my cases doesn't settle, it's not for a lack of trying.
Yeah. Very good lesson. Very good way to approach it, I think. Let me talk to you a little bit about your work with International Society of Barristers. We were talking about that all three of us were just recently in Maui, and that was our annual conference of International Society of Barristers. But you are the president, and I assume you got to pick Maui as your place for your year. Well, first, Ray, it was just an incredible conference. Every speaker was fantastic. Of course, Maui's gorgeous, but the conference itself was just amazing. So congratulations on an incredible week out there. But
thank you.
Tell us how you first got involved in International Society of Barristers, what it is. Some people are not familiar with it.
Absolutely.
You need to defend, you need to defend a group that would let all three of us in. There's a stiff order for you now.
Well, no, what I love so much about the barristers, unlike other law honor societies, the barristers came into existence because one of the, and I won't call names, honor societies was so heavily weighted toward big firm lawyers. Another one was focused almost exclusively on the plaintiff side. And so they wanted an organization that would be representative of cross-section of the bar, both plaintiff and defense. And where it would not be a matter of pinning medals on generals. If you get inducted in as an older lawyer, somebody over 60, you have to demonstrate you're still trying cases. And it celebrates the accomplishments of trial lawyers, plaintiff and defense, but it in a way that gives them some respite. Here's an opportunity to get together for fellowship with our families. It's very family oriented, as you know, and not talk about our cases. That's one of the last things we want to hear about, your big wins or what you lost, but to just have fellowship and enjoy each other's company, have some lectures on topics that from people you otherwise might not hear from. Somebody coming in and talking about astronomy. Another person is coming in and talking about the movies. I mean, it's enriching. History professor from Harvard. And so it is the organization that, and a BOTA, don't overlook that I've enjoyed the most. I got involved in the International Society. The state chair was Tommy Malone. Hugh McNatt was in it. So Hugh calls me one day and he says, I ain't supposed to tell you this, but I talked to Tommy. We putting you up for back. I want you to be in everything I'm in. That's typical McNatt. Anybody who's listening to this knows.
I love your impersonation.
What I spent so much time around. And so I got inducted in Carlsbad in February or early March of 2000. And I've been involved ever since. And I'd gone to Hawaii with ISOB in the past and meetings in other locales. But I got on the board of governors. Again, this was a recommendation that Tommy made to one of the past presidents. And the past presidents comprised the nominating committee. And so I was on the board, had all these meetings to go to, and I was hoping that once my tenure was up that, okay, I can get back to practicing and that sort of, just go to the annual meeting, and I'd have all these board meetings and the work in between. And the nominating committee came back and I was on the list of officers, secretary, treasurer. So you go up the progression. Unfortunately, we had not met in person since 2019 when we met this year in Maui. And I was at one of our meetings over in South Carolina. I think it was in Pine Bluff. And a couple of the spouses of past presidents says, we have not been to Hawaii in a while. This conversation is taking place in 2019. They knew that I was going to be president in 2022, so it was far out enough we could plan and budget for a big trip like that. And so I talked to my wife about it, and we decided we were going to do Maui. And it just turned out that there was all this pent up demand to travel and to be together because we hadn't spent any time together in 3 years. And so it, like you say, we had a great setting. We had a great program chair.
Largest attendance we've had, I think, maybe ever.
I think that's right. Yes, yeah. Absolutely. Yeah, it was a huge success by any measure. And I just love the people in this organization. They're like the two of you. I mean, they are people you enjoy being around, and that's part of the criteria for selection. I'll never forget this woman who spoke to us in Maui, who had suffered the loss of her arm and both legs in a car train collision. She's a radiologist, retired now, and but never gave up on life. Subsequently became a mother, a successful radiologist, and inspired others to go on and achieve. In fact, her physical therapist left physical therapy as a profession, went to law school, got a master's, and now is dean of students at the University of Southern California. She said to us in her closing remarks after she'd given her talk, she said, I don't know what the criteria are for selection for this organization, the International Society of Barristers, but whatever it is, you're doing something extraordinary, because I have never encountered a more caring, kind, compassionate group of individuals in all my days. And for me, that was the ultimate in terms of a commendation or praise of the organization and the quality of the people that we have in it. We enjoy each other's company. We care about each other. It's a small organization. I remember when I got in, Bill Lanham, who's also a member of the American College and some other organizations, said, that's my favorite one because it's small enough you get to really know the people. And it's my favorite one for that reason. It's the caliber of the people.
Same thing you said about one of our speakers one night while I was there, took the house car, that one of the bellmen drove up and came back, and he asked, what are you hearing? He says, we don't have a lot of groups here, but you have a great group, and said much of the same thing. And that's kind of stuff you kind of expect to hear from the hotel manager,
right? But
when bellhop volunteers it for you, they're speaking from the heart.
That's right. Lester, you hit the nail on the head. When you've got people at that level of the organization praising you, that's high praise. That's real high praise. That says it all. You're doing something right. And it says so much about the caliber of people who are in our organization. Not only are they great trial lawyers, that's undisputed, but they're just quality people.
One of the hallmarks of International Society of Barristers is collegiality.
Yes.
And we've certainly heard it demonstrated here today with how you approach your cases and dealing with opposing counsel. But Ray, why do you think it's so important to have collegiality between plaintiffs and defense counsel?
Oh God, I think it's in the best interest of the clients, the respective clients. I think it's in the best interest of the profession. It helps the judges in terms of just being more efficient, making their jobs easier. They're not expending resources unnecessarily, resolving petty disputes, things that we ought to be able to work out. And, for me, from a selfish standpoint, it just makes our work so much more fun. I can remember how much just enjoyment I derived from being able to work things out, get agreements on things. And the ultimate compliment for me was for someone to say, you don't have to put it in writing. Man, it just doesn't get any better than that. How could it be any better than that as a professional? You don't have to put it in writing. For someone to say that about me, or for a judge to say, well, if Ray tells me something, I can trust it. That it just doesn't get any better than that. And all of that's part of collegiality. Because when you practice collegiality, it's contagious. And the judges pick up on it, jurors pick up on it, that you're not engaged in the petty fighting. And so much energy is expended when you're fighting over little things and you're not collegial, you're not civil with each other. Just so much energy that could be devoted to the matter at hand, the end result, getting justice, getting fairness, getting a good result for the parties. That gets lost and gets sacrificed, in my opinion, when you have a lack of collegiality. But for me, from a personal standpoint, it just makes practicing law so immensely enjoyable when we get along.
Yeah, totally agree. And it's hard to explain to my lay clients sometimes. You represent corporate clients, but to my lay folks, it's hard for them to understand sometimes, but I tell them the fact that I get along with my opposing counsel, which I try to make a hallmark of my practice, inures to their benefit. Trust me, if I get along with opposing counsel, it's going to help my client.
That's right.
They may not see that, but ultimately, I do believe that.
It certainly does. And, one thing that will help lay people better understand it is if we're communicating and we're communicating effectively, then you're going to be the beneficiary of it. We're not fighting. I'm not spending unnecessary time fighting with somebody. I'm spending that time focused on what really is important on your case. I'm not chasing wild rabbits, which is at the expense of distraction from your case. I can focus on your case, and just being civil, it's just being polite and not taking things personally. And jurors pick up on it and judges pick up on it.
Very true. Ray, I'm wondering what a career you've had. Is there a possible highlight? If you could say there was one highlight of your career so far, can you name something, or is it just an incredible career the whole way?
Well, it's hard to. There are a couple of cases that stand out for me, and one involved an African-American woman who came to me. I was at Swift Curry, and she had a small newspaper. She wanted to be the legal organ for DeKalb County. The demographics in the county had changed such that there was an African-American sheriff and clerk of court, but not probate court. And all three of those had to decide on who would be the legal organ. The incumbent legal organ was a paper that was owned by the head of the Georgia Newspaper Association, so had wielded a lot of influence down at the legislature, and in fact changed the law while we were trying to qualify, meet the circulation requirements. We met them, but the probate judge sat on his hands, so I had to file a mandamus action against him. We tried the case, we won. They appealed, we went to the Georgia Supreme Court, we won, and it changed that woman's life because the revenue from being the legal organ enabled her to increase her circulation 20-fold. It enabled her to do things for her church and other community organizations that she otherwise wouldn't have been able to do. And it just changed, it changed her whole life. And it began with a visit to my office and our taking on the establishment, taking on the governor, taking on the newspaper organizations, the media, and in the courthouse.
And a judge.
That's where we got justice, and a probate judge, but we got justice at the courthouse. The other case I would cite was a milestone for me, was representing an investment bank from Kuwait. And they were sued by some founders of the Carlyle Group, and the case was tried in the Superior Court of DC. And you had a jury that was from modest means, varied backgrounds, but no professionals. And it was a very complex transaction involving some big real estate. So anyway, they were sued for $500 million. We had a counterclaim for attorney's fees. They had a venue provision in the contract. They wanted it in DC Superior Court because they figured these people coming in from Kuwait would not play well to a jury there. And so we tried the case. The case took 3.5 weeks to try. We got a defense verdict, and we won every penny on the counterclaim. And you can imagine how these folks felt about our system.
Mm-hmm.
And they went back to Kuwait having received justice in an American court. It was just, I can't begin to tell you what a sense of accomplishment and satisfaction that was for me personally, that our system worked. Mm-hmm. For folks who, were were skeptical
Yeah.
of what kind of justice they were going to receive in an American court, but they got justice against some very powerful people, very powerful people.
Great stories, great experiences.
I
Ray,
can just go on and on and on and
I
on.
know.
You know, it's
I could too. Could you share some advice to a young lawyer?
Yes. I
What,
think
what
that,
would your advice be to a young lawyer just starting out?
give some to old ones like me. And
well, y'all don't need
Robin too.
y'all
you know.
don't need it. You know all this stuff, but take care of the matter at hand. The best source of new clients are the clients you got now and other lawyers. And there are no shortcuts to success in our profession. It requires a tremendous sacrifice, especially personal sacrifice, personal relationships, in some instances, family relationships. It is a very demanding profession. It is not for the weak of heart. So unless you can give it 150%, you probably ought to be doing something else, because you're going to end up putting those clients before yourself. And that means you're going to put them before some of your family obligations at times. The profession requires it. The client's cases require it. Nothing less than your very, very, very best. And unless you're prepared to make that kind of commitment, that kind of sacrifice, go do something else, but stay away from the courthouse. That would be my advice, but that's what you got to do. There are no shortcuts, not without shortchanging your client or shortchanging the judicial system. You just can't do it.
Yeah, I hear these folks all the time, you know, complaining about practice of law, and so, some of that too is people who go into big law and maybe it doesn't fit them, or they go into hanging a shingle like I did, and they don't make enough money or whatever else. But I get sort of tired of people talking about how it's an awful profession because it didn't fit them. And I think one of the things that you acknowledge in what you just said is it ain't for everybody. No. You know, it ain't for everybody. But that doesn't mean that there's something intricately interwoven into the profession that makes it bad somehow.
Oh, heavens, no. And I tell you what, as a trial lawyer, I could not think of a more rewarding profession. You get to work on some of the most fascinating cases. You get to learn interesting topics, a broad range of topics. It's like a Renaissance career. You get to meet some of the most interesting people. You get to help people, and you get to give back to your community. You're an intricate part of a branch of government. I mean, it just doesn't get any better than this. Not from my standpoint. Sacrifice, yes, but the rewards. And I'm talking about the non-material rewards, because you can't do it for money alone. The money will come, but that's just a byproduct of this kind of dedication and commitment. If you've got this kind of dedication and commitment, those kinds of tangible rewards will come. But oh Lord, the intangible. That's what makes it worthwhile. That's what gets me out of bed every day. It's certainly not the money. It's the intangibles. Yeah. It's the chance to work with young lawyers, working on interesting subjects and learning just fascinating things.
Yeah, you definitely have to be a lifelong learner. That's something you want to do, because like you say, you have to become an expert on so many different subject matters.
That's right.
You know, I learned so much in every case right now. I've got cable barriers that go between medians on my mind, but I'm learning a lot about cable barriers.
That's right.
in a car wreck
exactly.
case.
Yeah. Roadway design.
Yeah, roadway design.
Like
I never thought I'd know so much about it, but it's just a great, I think it's a great career and great calling. I think you see it as a calling.
I do.
I see it as a calling, and I know Lester does too.
I do, Robin. That's precisely how I see it. It's a calling for me. It's not a job. It's not a profession as much as it's a calling.
I always point out that in most other common law countries, if you go look at websites of lawyers in other countries, instead of having the year they were admitted to the bar, like you got a ticket and you go into Six Flags and they'll open the gate for you, it says the year of call. It was the year you were called to be a member of the bar. And I've always loved that idiom, and I wish it were more, I wish we'd steal it here in America.
Me too. I like that.
Yeah. Ray, what two more things. First, before we get to the last question, I was wondering if there is a personal motto or personal tenet that you follow that directs your life and your practice as a lawyer. You obviously have just such an incredible reputation, not only here in our state of Georgia, but the entire country. Is there some either something of faith or just your saying or your mantra or motto that you say to yourself about the kind of person you're going to be or how you're going to treat people, or is there something like that in your life?
Yeah, the biggest influence in my life was my mother, and she told us that nothing was impossible with God. You can achieve it. And that was the driving force for me to become a lawyer. I worked my way through college in Savannah at Armstrong and was fortunate enough to get a scholarship through the Cleveland Bar Association to go to law school. But she was really the spark. And I guess in terms of how I lead my life day to day, and it would be this, that do unto others as you'd have them do unto you. Give them the same respect that you would want from them, and treat them the way you'd want to be treated. And I think if you do that, that's a good thing to live by.
I totally agree. The golden rule. Good way to practice law. Ray, we have one last question. I tried to prepare you for it, so you'd be thinking a little bit about it, but we ask every guest at the conclusion, and this has just been a wonderful discussion. We can't thank you enough.
Sure.
How do you define justice? What is your notion of it?
Well, in a word, it would be fairness. Fairness. And I know that's equally as vague as justice, but just equality, equitable. I don't know that I can put it any other way, but for me, it's fairness. And the fair result might not always be what you think it is or ought to be. And in the jury system, it's, what the jury comes back with. I oftentimes disagree with it, but then that's our system. And so, as I tell them in closing argument, I accept it. I accept their decision. And for me, that's justice in a jury trial. More broadly, it's fairness, trying to get to a fair result. We're trying to mediate a case. We're trying to settle a case, trying to get to a fair result. What's fair to both sides? And that can be very, very difficult, especially when you're not making the final decision.
Well, Ray, it's just been a delight talking with you. Let me remind our listeners that we've been talking with Ray Persons, trial lawyer and partner at King Spalding. And you can read more about Ray and his law firm at kingandspalding.com. Ray, thank you again. It's been a delight.
Thank you, Lester. Thank you, Robin. It's been terrific. I've enjoyed it immensely. And thank you for your friendship and being such stalwarts of the bar and leading exemplary lives that so many young lawyers can emulate. I'm proud to call you friends and counsel.
Proud to call you friend too, Ray.
Totally mutual feeling.
Yeah. Thank you.
You're welcome.
All right, Lester, great talk with Ray Persons. I'm wondering if you brought something to share with our listeners, that little legal news related item that we can share with our listeners.
I did, hot off the presses. We often have these things on here and we say 2 weeks ago in the New York Times, blah, blah, blah. Well, according to my iPad here where I pulled it up. This was posted 6 hours ago.
Oh, wow.
It's been going on for a long time, though, and it's an article in the Atlanta Journal-Constitution by my friend Mark Nisi, which is entitled "Georgia Voting Rights Trial to Begin After Years of Heated Elections." And the lead reads, "One of the most prominent voting rights cases in years is going to trial Monday, testing allegations that Georgia's election policies illegally obstructed voters from casting their ballots. The long-awaited trial will highlight complaints about voting problems in the 2018 and 2020 elections, bringing a parade of voters and elected officials into federal court to testify under oath about their experiences." And I think the significance of this is we frequently heard after the 2020 election from our former president that the election was a fraud, and there were a lot of claims that were rejected by the courts, some of which resulted even in discipline against some of the lawyers. This particular case began 3.5 years ago when it was filed by Fair Fight Action, a group Democrat Stacey Abrams founded following her loss to Republican Brian Kemp in the 2018 election for governor. Now it will be decided by a judge as both candidates are running again. And I think it's important. I think this is an important story. And it goes on, by the way, if you read it, it will go on to tell you what some of the issues are about how they reject absentee ballots and, things like this. But I think one of the most important things to know about that is Democrat, Republican, true, false, whatever, you have people that make claims about our voting system. And there is a way to actually get to the facts of those claims and find out whether they're true or not. And I think too many times folks say, well, who's making that claim? Is that somebody that I like? Is that a politician that I like? Or is that a politician that I dislike? Is it going to help somebody that I'd like to see get elected?
Yeah.
Or is it going to hurt somebody that I'd like to see get elected? And that's not really the purpose of the courts.
It's not outcome determinative.
Right, exactly. And so here you have, complaints about the voting system. And by the way, too, Judge Steve Jones, who has this, the story outlines a lot of the claims that were made by Fair Fight Action were thrown out.
Mm-hmm.
But there are others that were worthy of going forward. And, in a society that believes in the rule of law, we have to evaluate claims on the facts. And when the facts aren't there, when the facts are just made up, you're going to get thrown out of court. And sometimes you're going to have claims that you think are good, but aren't as good as you thought, don't meet the legal requirements. Those may get thrown out. And then there are others that, you put folks to their proof on and find out if there's actually some meat on the bones of their claim there.
Exactly what Ray was talking about with all of his trials. I regret it's in federal court because we're not going to be able to watch it online. No TV coverage in federal court. I would love to watch that.
Right.
It'll be some juicy stuff coming out of there, I'm sure.
And it's supposed to be, I have another case with some lawyers who are going to be involved in this. And we were trying to set a little bench trial that we're going to have for one of them's going to have to come away from that. And they said it was going to last 4 or 5 weeks.
Oh my gosh.
But you know how bench trials are, you may do 2 hours one day and 5 hours the next or something like that. So anyway, that's mine for today.
We'll be looking at that. Mine is out of Kentucky, my home Commonwealth. And the headline is lawyers could carry guns in court if Kentucky governor signs bill. So I think their legislature session just ended as Georgia's did. But Kentucky lawmakers have approved a bill that allows lawyers to carry guns in court. And it provides that any lawyer licensed to practice law in Kentucky may carry a concealed weapon at all locations if the attorney holds a license to carry a concealed weapon. So as long as you have a license, you can carry it in court in a trial or just like a judge. And the state senator, Johnny Turner, a Republican from Harlan, Kentucky, added the amendment. And his thought was that a lawyer should be able to protect themselves in court just like a judge or a bailiff. Now, we'll see. I don't think the governor signed it yet. Governor Beshear, Andy Beshear, is the governor, and all his office said is they would review the measure. It's House Bill 690 when it reaches his desk. So no promise to sign or not sign. But it occurred to me, I was thinking of that scenario. Of course, in Georgia, even if you have a concealed carry permit, you may not, listen, folks, you may not carry a gun into court. You don't get to do that. A judge does, sheriff deputy does, but not a lawyer. And going back to my first and last murder trial, a murder trial would be the last place I would want to have a gun, because I'd be concerned that the defendant might be able to get a hold of it.
Yeah, and I don't know if you know this, Robin, but in Cobb County, if you remember the Cobb County Bar, you get a card that you can, go in and bypass security. But Cobb County has gun-free courthouses, except doesn't matter who you are. If you're not a Cobb County Sheriff's deputy that's charged with keeping order, you can't take a gun into the courthouse. So if you're a Marietta City policeman and you go over there, they've got a locker out front, and you put your gun in there, and you lock the thing and you take the key. And then when you get through, you come back and get it. I have a concealed carry permit. We've had lawyers in Cartersville that have been shot before. And I believe it is one avenue available to protect me and my staff. Although, like you, I don't want one in court. I'm busy trying the case, not checking my briefcase or patting my hip, when I'm in there. But if you're a lawyer and a member of the Cobb County Bar, and you carry a gun, in your briefcase or whatever, you go into the courthouse, you can use the same thing that the police officers use. And I've done that. Before.
Just put it in a locker, but you're not taking it up to the courtroom.
Oh, no, it's outside. It's outside the courthouse.
The thing I worry about is, what if something, you're in the middle of a trial and you've got a gun on you, something goes wrong, or somebody just loses his what and takes it out on you and tries to grab your gun. I just think it's a bad idea to have lawyers have guns.
A lot of judges won't let witnesses testify if they're armed, like police officers. And I sort of agree with that.
I do too.
I think it's I think it makes sense. I mean, a courthouse is where you fight a war of words and not a gun battle.
That's exactly right. Well, we'll be seeing if Governor Beshear signs that, but I'm pulling for him that he doesn't. We'll see. Well, Lester, that's it.
It is, absolutely. But it's been a great show today.
Yeah, great show with Ray Persons, and then we have another episode coming up soon. So, Lester, until next time,
we'll see
you in court.
Thank you for listening to See You in Court, brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com. The producer of this podcast is Raz Misher. We thank Noreen Hassan, Associate Professor and Director of Outreach and Community Engagement of the Georgia Institute of Technology School of Literature, Media, and Communication, and the Georgia Tech students who help bring you this podcast. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at fairplay.org. On behalf of Robin Fraser Clark and Lester Tate, until our next episode, we'll see you in court.